is in connection with the death of her 5-year-old daughter, the shooting death of her daughter, Destiny. This happened back in 2019. The case went to trial last week. Thanks so much for being here. Let's first set the stage and talk about the case itself and how we got to trial.
A very tragic case where a 5-year-old was shot, and it was a case that had a lot of mysteries, a lot of twists and turns. And, you know, Mark Twain gave the old adage, good liars give details, great liars don't. And I think, you know, part of the dynamic that led to this conviction, but which really was a good result, depending on the facts, was that the mother told lie after lie after lie. So, terrible tragedy. You have a 5-year-old that was shot. The first story Howington told police was an unknown perpetrator walked in driving a black 300 Chrysler, shot the 5-year-old, ran out of the house. It never pans out, never makes sense. The mystery kidnapper shooter. Second story, the biological father, baby daddy. They had an argument, shoots the 5-year-old, drives off in not a black 300 Chrysler, but a white 300 Chrysler. That's the only consistency. Story changes for a third time. She says that her 2-year-old, now this is remarkable, and it turns out everyone thinks this is the true version of events, got a stool, climbed into the mother's closet, retrieved a firearm, a pistol, and shot the 5-year-old. Story number 3, but while she was charged with felony murder by aggravated child abuse and neglect, which carried 51 years, she was charged with aggravated child abuse and neglect, giving 3 false statements. She also lied repeatedly about where the gun was, destroying the gun. She also wiped fingerprints off the weapon.
Tried to destroy her cell phone when she got to the hospital.
Right, but that's the backdrop that this jury heard. It was covered by Court TV here in Knox County.
Yeah, so then we get to the point of when the jury knocked down that murder charge.
Yeah, it went from a murder charge to reckless homicide, and that's a big difference. Explain for us, Greg, I think, how a jury can say, yes, a crime was committed, yes, you were guilty of this, that, and the other, but let's take down one or more of these charges.
Yeah, what about this case would lead them to render that decision?
Well, it's interesting. You know, again, the only consistent evidence was that the 2-year-old actually shot the other sibling, and that was based on a text that the mother sent that the 2-year-old had fired the weapon, and there was GSR, gunshot residue, on the clothing of the 2-year-old. But to me,
the mother's dress.
And the mother's dress. But it's remarkable that a 2-year-old would have the physical and mental ability to retrieve a firearm and pull
That
the
was
trigger.
my initial
Yeah,
thought.
I was really struck when they brought out the fact that they had actually measured the 2-year-old's hand. You know, to compare how the 2-year-old's hand would barely even be able to reach around the pistol, the trigger, and then to have to squeeze it. I don't
even think you could ask a 2-year-old to get a toy gun and play like they're shooting, and they would comprehend and understand what they're doing, much less take their time on their own initiative to get a chair, retrieve a real firearm, know how to.
I just don't see that happening.
It's insane, but oddly enough, both the state and the defense kind of agreed, and that was the narrative presented to the jury. But Jeff, here back to your question, how do you get to this verdict? And you know what? It makes no sense. And I think sometimes juries do what they think the right thing is, because she was charged with felony murder. Now, what is felony murder? That means you commit one crime and you're vicariously liable for another. A lot of national media organizations have really taken Tennessee's felony murder law to task. I think the Atlantic did an expose on how you commit one crime, you're involved in a robbery, and then you're doing 51 years for a homicide. But there are certain enumerated felonies that trigger felony murder: arson, robbery, burglary, theft, kidnapping, aggravated abuse of the elderly, aggravated child abuse is what we had here, aggravated child neglect. One I've never seen in 35 years, aircraft piracy. So when you're stealing that plane, you put the G4 in your garage and you do that and someone gets hurt.
Wow, I haven't heard of that one. But you did bring up the child abuse aspect of this.
But listen to what the jury was told. Felony murder is the killing of another committed in the perpetration or attempt to perpetrate any, and let's read, aggravated child neglect or abuse. So they found that the Howington committed the triggering offense, the felony, but yet didn't commit felony murder.
Because they're saying she didn't, in effect, pull the trigger.
Would you-
Is that what this all
but
boils
she was
down
convicted.
to?
Let's look at what she was convicted of. She was convicted of aggravated child abuse and neglect, which carries 15 to 25 years, which is a felony that would have supported felony murder.
Right.
So if you legally look at it, if you're convicted of this, the jury should have checked guilty in the box. So what
Why
you have
didn't
is-
they?
Would you call this jury nullification then?
It is jury nullification.
Okay.
And
Interesting.
So that's so interesting. And again, that would have been a 51-year sentence, the felony murder for aggravated child abuse and neglect. Negligent homicide is only 2 to 4 years.
What about reckless homicide?
That's 2 to 4 years.
2 to 4 years.
That's what we're talking about. But the kicker. Let's look at what she's convicted of and what she's going to be sentenced. The aggravated child abuse and neglect is 15 to 25 years. Tampering with evidence, wiping the gun, a C felony 3 to 6. False reports, another 3 to 6, and then tampering 2 to 4. So she's looking at a potential sentence in the decades, notwithstanding.
What do you think's
no
going on
felony
in the
murder.
mind of the jury, though? I mean, how could they arrive at this decision knowing what you just laid out for us?
Explain a little bit more about nullification.
Jury nullification means that the jury does what they think is right, because here's how it works.
They think is right, not the law.
The law.
Yeah.
You've sat on a jury before. And Jeff, I don't know if you have, but you hear the trial, then the judge reads lengthy instructions on what they're charged to do, what the rules are when they go back and deliberate. It takes an hour and 20 minutes, and it's thick. I mean, it explains everything, defines witness, evidence, credibility of witnesses, etc. And after a while, you're inundated with that. You've got the emotion of a trial. And, sometimes juries do what they think is the right thing. Now, think about it. If you believed that a 2-year-old climbed up in the chair, mom didn't really know anything about it, killed the sibling, terrible tragedy, let's not punish this mother with felony murder, but let's make sure. I mean, she shouldn't have had the gun where it was. And I think the other thing with this jury that wanted to return a verdict that would be considered jury nullification. That's just basically disregarding the facts and the law. I don't think they knew that the aggravated child abuse and neglect was that steep of a sentence, because under Tennessee law, they don't know. We can't argue how much jail time is going to be there. You can't even argue jail time. You can just say convict, acquit. So,
Interesting.
I think they thought they were really doing the right thing and giving Howington a favor. But in reality, she is still facing decades behind bars.
What about the power of the judge? Could the judge step up and say, I don't agree with that, given everything we've just said about the jury's decision?
Very rare, and I think what Judge Green did that now every judge in Knox County does, because Judge Baumgardner in his latter days forgot to do it. And he says, as the magic words, as 13th juror, I accept your verdict. And that happened in this case. So where Judge Green has got the ball's going to be on him, and the eyes of Knox County and Court TV are going to be watching, what does he do with these 5 offenses she was convicted of? Does she get the maximum? Is he going to try to stack the sentences? Because there's going to be an argument they should be consecutive, not concurrent. Is he going to buy into the fact that the jury saw some redeeming qualities in this case and fashion the sentence where they maybe run together?
But the whole fact that she lied and had so many stories really damaged her credibility. So her unbelievability, how does that play in?
I mean, it's a factor. Jurors are human. Judges are human. But, again, this person told lie after lie after lie, and she couldn't help herself. I mean, Jeff, as you mentioned, she's at the hospital trying to destroy her phone. I mean, she's wiping the gun, hiding the gun, paying people drugs to come get the gun. I mean, it was a one-person, crime wave.
Well, and the defense argued, she has PTSD.
Yeah.
And she was trying to protect
Her
the
2-year-old.
two-year-old.
That's I think, Greg, I wanted to see if you would talk to us about. You mentioned that the aggravated child abuse effectively triggers another crime, but even though that further crime isn't part of what the jury found, the statute. There's something called Haley's Law, and it has to do with the fact that aggravated child abuse was committed, but the child was 8 years or younger. And then that makes it takes it from I believe from a B felony to an A felony.
And her dad, her father, is got 100 years.
The Haley Spicer.
The Haley Spicer. We did
Right.
lots of stories on her, horribly abused.
And that, Jeff, that's exactly accurate, and that's a good point. But in this one, it was aggravated. So aggravated
Okay.
starts out as an A, so you don't have to have that level of going from 8 to 12 to 15 to 25. But if it was not aggravated child abuse and neglect, it was just abuse and neglect, Haley's Law would have kicked it up to the same sentencing exposure.
Okay. And then I just think at a general, she took the stand in her own defense. And that seems to be, a lot of people think if I were accused of a crime, I would want to make my case to the jury and say, listen, I didn't do this, believe me.
But usually that's so frowned upon.
And that does also go to what, Lori, you were mentioning about her credibility. How can you, after being, accused of and maybe proven of lying, take the stand and say, no, jury, believe me, please? Would you have put her on that stand?
Well, that's tough, and let's talk about how that actually works. And during voir dire, when you're asking the jurors questions, when you're going through that interview process, you want to make sure that if my client exercises their constitutional right that they have, you have, I have, not to take the stand, because it's the state's burden to prove each and every element beyond a reasonable doubt. We as American citizens never have to prove our innocence. Would you hold it against it? And everybody, some say, kind of, sort of, and you kick them. You get them out of the courtroom, out of the jury. But more often than not, I mean, sometimes, I had one case, Norman Clark, that's on Dateline Court TV, and I promised everybody in an opening statement that you're going to hear from my client. I stood up, first thing I said was, I lied. I said the state failed miserably at proving this case, so we don't have to put on any evidence. So it's a judgment call. And let me tell you how important it is. There is something that we have in Tennessee called the Momen colloquy. What's that mean? Fancy word for a name of a case. That means ask questions. The judge, out of the presence of the jury, asks the client, do you understand you have the right to testify, not testify? What do you want to do? So behind the scenes, everybody's kind of making sure that this doesn't come up and bite us in appeal. But, this is a tough case because I think, you obviously had this person that was going to be impeached over and over and over, lie after lie after lie, and you had to put her on the stand and turn her over to a prosecutor was a gutsy decision. But,
And some people
worked.
would argue that she is not a sympathetic character, just to look at her. And that's what a lot of people had said.
Showed a
She
lot of
looked
emotion,
tough.
but for some people, they just don't buy the emotion that you're
Correct.
putting out.
Correct.
So
Her
that's
whole
something
demeanor.
Yeah.
Everything.
I also thought, Greg, I ultimately, when you, assuming that this is the facts of the case are that a 2-year-old shot and killed their sibling, which, okay, let's just go with that assumption. Why not just say that's what happened? Why bother with this whole rigmarole?
She would have faced a lot less time.
I don't even know that. Would she have faced any time? Yeah, maybe she would have lost her child, but I
Call
just,
911 and say, oh no, this is what happened.
Martin Luther King said when there's injustice anywhere, there's injustice everywhere. And justice depends on the county in Tennessee and the prosecutor you're dealing with. Some prosecutors will look at the facts if this woman would have been honest and said, hey, let's resolve it in a reasonable manner. Some take the stand, this person's a liar, we don't think it happened this way, we're going to trial. So, it just depends on who the players are. And, the interesting thing, and these cases are convoluted, under Tennessee law, we have the Victims' Rights Act codified in our Tennessee Constitution, and, the prosecutors defer to the victims. Well, who's the victim? The mother and who's the defendant and the 2-year-old? So really crazy, but that's a great question. If the facts are that a 2-year-old accidentally shot somebody, why all this craziness? Stories, again, back to Mark Twain, good liars give details, great liars don't. and it could have been simply resolved, one would think.
And the real victim here is that little 5-year-old girl.
Well, and the 5-year-old and the 2-year-old, and you know, you'll have a family that's split up. But you know, if I'm on that jury, I'm going to have a hard time having any empathy or sympathy, because not only did she try to blame it on a stranger, but to blame it on the child's biological father. I mean, she was willing to set up and frame someone totally innocent to protect herself and protect her 2-year-old.
Before we let you go, Greg, one more thing. Does this go to an appeal? Is there grounds for appeal here?
Well, Jeff, I don't know of any case now that doesn't go to an appeal. And there's always grounds for appeal, and there's always motions. Every time there's an objection, every time there's a jury selection, you have a basis for appeal. So, you know, I think you will. But, you know, again, you look at this case in one way, a good result for the defense, and you look at it another way, this person is going to be doing a lot of time. But think about this. It's all the defendant's doing. I mean, tampering with evidence, destruction of evidence,
Lying.
false statement. And those lies are going to cost her about a decade worth of lies.
All right,
That's
let's
a lot of
end it on
lying.
that. And we'll talk more about this at 5:30.
Look forward to it.
All right, thanks for being with us.